All right, we'll go back on the record in the case People versus Brandon Willie Martin. That's RAF 1506112. Record should reflect Mr. Martin is present with both counsel. The people are present. For sentencing, people wish to be heard.
No, thank you, Your Honor.
All right. Mr. Welborn, Mr. Jensen, do you wish to be heard?
Submitted. We're going to talk about the fines.
All right. Just a couple of comments before we get to sentencing. First off, I want to thank all of the victims' families for being here today under these trying times of COVID. I know it's difficult to get out at the best of times. I do want to thank you for your difficult but heartfelt comments to the court. One of the troubling things of the many troubling things that I heard during the course of the trial was, and I'm talking about the Swanson family, but I think it applies equally to the Anderson and Martin families as well, is the fact that these three fine individuals, these three fine men, were the glue in the families. And as a result, many of you have grown farther apart and have not had an opportunity since the time that these horrible crimes occurred to spend time with each other or be close again, because the glue in your family is gone. The comment that I have for you is kind of a personal one. When I was born, I had a sister and a brother. They were both older. My sister is 9 years older than me, and I was always close to her and still remain close to her to today's day. My brother was 16 years older, and I was never close with him because he was practically out of the house when I was old enough to know he was around. And through life, we remained not close, not just because of the age difference, but because he saw the world in a different way than I did. The glue in my family was my father, and he insisted on Sunday night family meals that all the family would attend, including my brother, my sister, and families. And I can't recount the number of times that my father would say, call your brother, see your brother, he's your only brother, spend time with him. And I didn't really take the opportunity nearly enough. In 2006, my father passed away, and so the glue in my family passed away. I continued to be close with my sister, but my brother and I drifted farther apart. And I actually didn't hear from him again until late in 2007, when I was told that he had only days left to live because he had inoperable cancer. So I had an opportunity to go out and see him, spend a couple of days with him. And one of the last things he told me was he wished that he had been closer to me during the course of our lives. And I certainly shared that thought as well. The point of that story is for all of you, while that glue is gone, you are all still together. And certainly your fathers would have wanted you to be close together, would have wanted you to stay close together, if anything, get closer together, because you won't get a second opportunity. Life has a strange way of meeting out various different obstacles, and one never knows when a sibling or relative may be ill or may pass away. And so your opportunity to get close and reacquainted is now. And so if you heed these words, I would strongly encourage you to consider it. It's certainly what your fathers would have wanted. This case was certainly a troubling one in many aspects. The defendant in this case was, and by all accounts, a talented baseball player. I think I heard testimony that he was one of the top prospects in the state of California. He was going to be the next Derek Jeter. He was drafted at an early age, signed a very large monetary contract to play in the Tampa Bay Devil Rays organization. And unfortunately, Mr. Martin didn't take advantage of that talent. Instead, he squandered it by using drugs, partying with his friends, And it ultimately caused, of course, both the team and his family to disassociate themselves with him as best they could. And, of course, we know the tragic consequences that occurred in this case, which included him physically and verbally assaulting his parents and his family. And then when he was diagnosed with his mood disorder, he was provided medication to treat that illness and apparently chose to stop taking that medication and self-medicate with illegal substances. His talent and his contract and all of the opportunities, and maybe most important, the closeness and love of his family were squandered. It is sad and alarming that the defendant was capable of taking the life of not only his father and his uncle, but a complete stranger who was there just to help the family. And what's most alarming is how it was done, and the fact that the defendant utilized his signature baseball bat to cause all of this damage. That bat which opened the doors to what would have been a successful future caused for the brutal murder of his family and a stranger, Mr. Swanson. And moreover, the manner in which it was done, it's clear to the court that first, Michael Martin couldn't defend himself given his physical deficiencies. He was in a wheelchair, couldn't raise his arms. Ricky Anderson, I think, was completely caught unawares and was probably hit in the back of the head as a first blow. And then, as we heard some comments today, and as the evidence bore out, Barry Swanson did not just his job in an attempt to protect the family from the installation of the alarm system, but came to the aid of both individuals that were there. And it's sad, the outcome of the incident, and of course the infliction of emotional pain on all of the victims' families. So it is certainly apparent to the court that Mr. Martin presents a serious danger to the safety of the community, and therefore he should be punished to the fullest extent of the law. And so the court will follow the following rules of court, and I'm talking now about counts 4 through 7. As to Rule 4.421A, factors relating to the crime, under 4.421A1, the crime involved great violence and great bodily harm. Under Rule 4.421A2, the defendant was armed during the course of the crime. Under Rule 4.421A3, the victim was particularly vulnerable. Under Rule 4.421A8, the manner in which the crime was carried out indicated planning and sophistication. Under Rule 4.421A11, the defendant took advantage of a position of trust. Factors relating to the defendant under Rule 4.421B, the defendant engaged in violent conduct that indicated a serious danger to society. Under Rule 4.423A, factors relating to the crime relating to mitigation, there are no circumstances in mitigation. As to Rule 4.423B, factors relating to the defendant, the only factor in mitigation in this regard would be under Rule 4.423B1, in that the defendant had no prior record at the time of the incident. And so it will be the judgment order of the court as follows. As to counts 1 through 3, probation is denied. The jury, having found the defendant guilty of murder in the first degree as to each of those murders, which is punishable by either death or life imprisonment without the possibility of parole because of the special circumstances that were alleged and found true. At this time, the court will sentence the defendant on count 1, 2, and 3 to life without the possibility of parole. As to each of those counts, attached is Penal Code Section 12022B1, which is for the weapon that was utilized. As to each count, the court will impose 1 year consecutive to one another for a total determinant term in those 3 counts of 3 years in state prison. As to count 4, which is the 2800.2 of the Vehicle Code, this being a determinant term, the court will sentence the defendant and find this to be the base term of the upper term of 3 years. That term is chosen because the aggravating factors far outweigh the mitigating factors. As to count 5 and 7, count 5 being the 69 PC, which is the resisting arrest, and count 7, the 10851 or vehicle theft, the court will sentence the defendant to the midterm on each of those counts of 2 years. By operation of law, it would be 1/3 the midterm, or 8 months consecutive on count 5 and count 7, consecutive to count 4. And then finally on count 6, the misdemeanor, which was the cruelty to an animal, the court will find the defendant to be imposed a 1 year in county jail, that sentence to run concurrent to the determinant terms and may be served in any penal institution, making the total determinant term 7 years and 4 months with 3 life without the possibility of parole sentences. Court will credit the defendant with the following days: 1,961 days of credit. He is not under 2933.2 entitled to any good time credits, and so his total credit time will be 1,961 days. Court will order that the defendant submit to a DNA test pursuant to 296 of the Penal Code unless he has already done so. As far as actual restitution, probation, I know, either did contact or attempted to contact family members and apparently were unable to discern an amount for all 3 of our victims in this case. Is it the people's wish for the court to simply re-refer and retain jurisdiction?
Yes, please.
All right. Then as to the restitution to the family of Michael Martin, Ricky Anderson, and Barry Swanson, court will refer the matter back to the Riverside County Probation Department for further inquiry and investigation, and court will reserve jurisdiction with respect to restitution. Any amount that is found to be due and owing needs to be provided to the court, to counsel on both sides, and if in the event there is any dispute, we can conduct a hearing on behalf of Mr. Martin. Court further found in the probation officer's report that both of the officers, Officer Bejeans, B-E-J-I-N-E-S, and Officer Marquez, M-A-R-Q-U-E-Z, apparently there was no restitution due and owing. Any objection from the people to the court setting it at 0?
None.
All right. At this time, court will set restitution to Officers Bejeans and Marquez in the amount of $0. As to the restitution fine, did the people wish to be heard?
No, Your Honor.
Defense?
Yes, Your Honor. If you're speaking about the state restitution fine, I see that the probation department has asked the court to set it at $10,000. We would be asking the court to set it at the minimum based on the fact that Mr. Martin, he's been incarcerated for so long, he financially cannot pay that. I believe it's appropriate to set it at that $300 level. So we would object to the $10,000.
People?
We'd ask for $10,000, follow the recommendation of probation, Your Honor.
All right. I know that there is a complex mathematical formula that probation utilizes in order to calculate the restitution fine. It's under 1202.4b2, where the minimum fine is multiplied by the number of years in imprisonment and various other calculations as well. I certainly recognize that Mr. Martin is not going to be earning much of prison wages, nor would he have the financial ability at this point to pay the restitution fine. At this point, the court will impose a restitution fine in the amount of $5,000. That's under 1202.4, and court will not impose a restitution fine under 1202.45, and the reason for that is the defendant is not going to be eligible for parole, so no parole revocation restitution fine will be set. A $5,000 restitution fine, however, will be imposed. Court will further order the following fees imposed for a criminal conviction assessment fee under Government Code Section 70373, $30 per convicted charge for a total of $210, and court operations assessment fee of $280 or $40 per convicted charge under Penal Code Section 1465.8A1. Mr. Martin, you have a right to appeal anything that happened during the course of your trial, including anything that happened during today's sentencing. If you wish to do so, you must file that notice within 60 days of today's date. Your failure to file that notice could result in your loss of such appeal. Your attorneys, no doubt, will help you with the filing of the notice. Also, sir, the sentence the court has meted out today contemplates no parole because it is a life without parole sentence. However, if for any reason in the future the parole board were to parole you, your parole period would be for a lifetime parole, and any violations of that parole would result in you going back to state prison for another life commitment. Do you understand, sir, both your appellate rights and your parole rights?
Yes.
Court will find that the defendant is not in possession of currently any firearms and therefore is in compliance with Penal Code Section 29810. Court does have the paperwork filled out. Is any of the family members requesting a criminal protective order?
One second. There you are.
All right. Then, for the people, is there anything further on the sentencing?
No, Your Honor. People submit. Thank you.
Defense?
No, thank you.
Thank you.
All right. Then at this time, the court will order that the defendant be transported forthwith to the Department of Corrections for immediate housing in that system. Thank you.
Thank you, Your Honor.
Thank you.
you.